Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3087, United States of America versus Troy Anthony Smocks, also known as Kenneth Harris, also known as Tony Sanders, also known as Vincent Shelton, also known as Troy Perez, appellants. Ms. Wright for the appellant, Ms. Fleming for the appellate.
Good morning, Ms. Wright.
Good morning. May it please the court. Lisa Wright for Mr. Smocks. I'd like to reserve 2 minutes for rebuttal. The district court here erred in modifying Mr. Smocks' supervised release condition to add a forced installation of computer monitoring software without properly weighing the public's interests against the deprivation of Mr. Smocks' liberty. Some brief background: the original PSR mentioned computer monitoring / search, but didn't have any reference to any software. The software reference first appeared in the probation officer's sentencing format. It's not clear if defense counsel saw that. At sentencing, the court read the sentencing format.
Why
And
should we presume that defense counsel didn't read the pre-sentence report?
not the pre-sentence report, the sentencing format that comes at the back of the probation officer's recommendation. It's my understanding that counsel doesn't always get that. I notice it doesn't have a number on the docket to even click on. So I think that means that it may have been inaccessible even to counsel. I'm not sure. And so what the court read really was a little bit nonsensical at sentencing. Of course, there was no appeal. He waived his appeal. So that was that. He finished his 14-month sentence a few months later, and then 6 months after that, probation came to him and advised him that he had the right to a hearing before any, quote, unfavorable change in his release conditions. Asked him to waive that, and he declined. So the probation petitioned to modify and add this software installation requirement, which the court did over counsel's objection that the 3583D standard had not been met, and this appeal is of that modification order. The district court was required to weigh the deprivation of Mr. Smocks' liberty against the need for deterrence and public safety, and to choose the least restrictive alternative to accomplish those goals. And Melania requires a narrow tailoring to the purposes of the restriction. And the court here purported to weigh and balance and choose the least intrusive means. But that evaluation was really impossible because the court didn't identify the scope and target. There was no restriction that the monitoring was enforcing, or any description or thought as to how the monitoring would take place. It seems that the nature of the monitoring wasn't really considered, and that the monitoring condition seemed to just be presented to the court as a less restrictive alternative to a computer ban or an internet ban or a restriction, but not what monitoring options might be and whether the monitoring option that was being ordered.
Where did the defense attorney say, this is how we think that this should be restricted, this and not this? I don't see that was ever said to the district court.
Well, he was objecting generally to this deprivation of liberty.
I mean, that's my point. But that seems to be a different argument than the argument that you're making, which is that even if the software could have been loaded, it should have had some restriction than just to monitor everything.
I guess the way I'm thinking of it is something was ordered, and that something, which frankly, we don't know what the reality of it is, the weighing was never done on that something because the something wasn't specified, and nor was there a specification of what it was looking for. And most of these cases, of course, are like child porn cases where there's very few cases that you could find that aren't child porn cases. And so obviously, they're looking for images, they're looking for certain things, and you can put in like filtering software, and that's been upheld many times. But it's unclear here. This was just looking for criminal speech, it sounds like. But yet it wasn't even said that. It wasn't said, don't say this, don't do this, don't look here, don't post there, and we're going to monitor you to enforce that. It wasn't paired with anything. And I would point to the Albertson case where they said that that's the Third Circuit, where they said that software is generally acceptable if the internet restriction to which it applies is narrowly tailored, and that reasonable method of monitoring and filtering can be reasonable methods of enforcing a more targeted restriction. And there's no problem with the monitoring if it's paired with a narrowly tailored restriction. But here it was like a free
I'm trying to make
floating.
sure I understand your argument. Are you saying that at the time of sentencing, Mr. Smocks and his counsel were not on notice that the monitoring that would be done was going to be done using software?
I mean, they were told that at the sentencing. Possibly they saw the format ahead of time, but I mean, they saw the word software. That's the first time it came up. But the monitoring.
So I mean, so they knew that it was going to be software, and he waived appeal of supervised release conditions as part of waiving appeal to the sentence unless it was an illegal sentence. So I'm trying to understand then if he waived appeal of supervised release conditions and he knew, at least as of the time of sentencing, that that meant that that would include software used to monitor. How is it that it's properly before us to essentially revisit whether or not it's appropriate just to load any software on the computer at all?
Well, yeah, I now understand the question. Like, we disagree with the premise that he knew there was going to be software, because what this special condition just says, you must submit your computers or other electronic devices to a search. Wait a minute. Where is it? I'm sorry, I'm in the wrong place. Sorry. To ensure compliance with the computer monitoring condition, you must allow periodic searches, and then there is in that reference to software. But if you just read this or you're just listening to this, you think, okay, compliance with the computer monitoring condition, but you're like, what computer monitoring condition? They forgot to put that in there, essentially. They just have like a heading that says computer monitoring / search. They don't say you are going to be subject. First of all, they don't say you can't do such and such on your computer, and we're going to subject you to a computer monitoring condition, and then say to comply. So it's not clear that this whole condition has any relevance to him at that point. And he's not objecting to it. He doesn't have a right to appeal it. And it doesn't appear that it's even going to be a problem. And in fact, it isn't a problem for like 6 months when they come to him, and they are the ones that say, we want to change
Well,
it.
they come to him because he's getting out of prison at that point.
Well, he'd been out for at least 6 or 7 months at that point when they came to him. He got out, I think, in January, and they came to him in end of July, and then they petitioned early September to have it put in. And they're the ones that said, this isn't covered. This hasn't been ordered. This is new. We're unable. I think they say the current condition does not allow us to do it, and we're unable to install it without. That's what it says in the petition.
When the modifications took place, what was his objection in the district court? What was the basis for the objection?
Well, he said several things, but his overall objection, and he quoted the statute in full. He said that that it had to be he read 3583. Let me just find that.
I asked that because, as I recall, the government says that a good deal of the argument that you're presenting to us was not presented to the district.
Yes. Well, he called this off. First of all, he quoted 3583 in full, which says, sorry, it says that the language about it has to be a deprivation no greater than reasonably necessary. He called the software, quote, unnecessary and overbroad, and he argued that the, quote, deprivation, including these privacy and interference with his legal work interests, were, quote, not reasonably necessary under the law. So he made a very broad challenge.
There was no objection on the basis that the terms of the monitoring were contradictory.
Right. I mean, right. That's right. But that's not really what we're saying now. We're making the same broad objection that he made at the rehearing.
That's right.
Yes.
If we understand the modification to really be a kind of a clarification of the terms, would the appeal waiver cover that?
No. I think the Third and the 10th Circuits have both said that, first, of course, the appeal waivers are construed against the drafter, against the government, and this court has done that and construed them narrowly. And the Third and 10th Circuit has held that appeal waivers don't cover post-sentencing modifications of
Well,
supervised release.
modification, but what if it was a clarification? Would a clarification be covered
Um,
by the appeal waiver?
Well, again,
I understand that.
I guess if
that
it
the
was-
district court called it a modification and you take it to be a modification.
Yeah.
Assuming that I thought it was
Yeah.
a clarification, would the appeal waiver cover that? Because then it would be part of the sentence in this case, wouldn't it?
I guess, yeah, arguably so. I'm not conceding that. But here, the probation characterized it as a change, an unfavorable change. They weren't considering it to be a clarification.
And are we bound by the formalism of that label?
Well, I mean, technically, I mean, you can just read it and it doesn't authorize it. Probation didn't think it authorized it. I mean, it didn't authorize it, doesn't authorize it. In fact, it's just sort of nonsensical. It talks about to enforce the computer monitoring condition. And when I first picked up this file and I knew it had something, I just was told like, this is a computer monitoring condition. I looked at the old JNC as the first thing I looked at it, and I read the thing and I was like, what computer monitoring condition? I mean, that's what you think when you read it. And yeah, I mean, it is, I guess I'm not saying you're bound by what probation said, but it's certainly, they don't think their own terms, and they clearly do have terms to choose from. They just like didn't put them in. I mean, they have recommended language and they opted for like sort of the compliance thing instead of the actual imposition. And again, they didn't pair it with any kind of, it's like a free floating monitoring, which in this outside of the like porn context, it's really like, I don't know how anyone, it would be impossible to evaluate it. And comparing it, I think what happened here is the court compared it to a ban and said that's less restrictive than a ban, but they didn't compare it to any other kind of monitoring.
Well, what did the government say that the monitoring would accomplish?
The government?
Probation,
Yeah.
prosecutor, anybody? And what did they say that the monitoring was
It would
going to
deter-
look for, and what would it flag or?
Well, they certainly weren't specific. They just said it would deter future criminal conduct, basically. And the judge, when he complained it was going to interfere with the First Amendment, the court said, well, this is only looking at criminal speech. So it seemed like they were saying, don't commit any crimes, and we're going to be randomly looking through your computer. I mean, we don't know what they're doing with the computer, but to just look for crime in general. The court said that.
Well, I guess what I'm trying to get at is there evidence in the record that the monitoring software was going to allow someone in the probation office to watch his every keystroke and to look at every email and to look at every web page that he visited? Or is the evidence that they would be able, the software would allow them to kind of go back, and if there was something concerning, they would be able to find it because the software was there that was essentially kind of capturing what he was doing, and they could kind of use that software to search for something?
Absolutely nothing in the record about that. And that's our point. Like, that is our point, that like, if the court doesn't know what it's ordering, it can't weigh it. It said that it was.
But if the court, if like those points weren't like directly made to the district court, then how's the district court erring. In like what I just said, I don't see where the defense lawyer said that.
Well, because the court has an obligation to weigh, and the judge, that we said this doesn't, the balance doesn't allow this, and the judge has to then, the judge has this independent thing. It's not like have to ask for each little thing. You're saying weigh this, and if the judge doesn't do that or can't do that because of they don't know what they're ordering exactly, there's no specification. It's covered by the objection, I guess is what I would say. And the court also said like this, said the monitoring condition was, quote, limited to balance Mr. Smocks' interest with the public's, but that is not, there was no limiting. The monitoring restriction wasn't limiting it at all. It just said monitoring and filtering. And again, we point to Albertson, and I guess our overall argument is that, like, you know, when the court has to be the one that narrowly tailors it, not, you know, there has to be guidelines. Maybe probation can like work out the fine points, right? But the court has to tell them what they're supposed to look for and like what scope of places they can look. And if they don't know that, then that's not weighing, that the doing the weighing that we objected couldn't be satisfied. You just aren't doing the right weighing that we asked for.
And where's kind of like your best citation in the record for the argument that you just made, having been made to the district court?
Didn't put the page site there. It is on, let me just quickly find that. It's at the modification hearing. No, it's in the opposition to the petition, and it's on pages like 94 or 93 and 94.
Of your appendix?
Yes, of my appendix, where he quotes, the court may order condition of supervised release to the extent it involves no greater deprivation of liberty than is reasonably necessary for the purposes, and quoting the statute. And then he says that it's unnecessary and overbroad and unnecessarily, it's not reasonably necessary under the law, necessarily overseeing communications. So that's what I would say. So we would ask for these reasons that the software installation order be vacated and the case will be remanded for the required 3583D inquiry.
Thank you. Ms. Fleming.
Good morning. May it please the court, Mary Fleming for the United States. The software installation condition is part of the original condition of computer monitoring, which Smocks did not object to below and is not challenging on appeal. And because the installation is part of the original condition, the appeal waiver bars this appeal. And regardless, the district court did not err in ordering the installation of monitoring
So why
software.
did the government seek a modification? It was part of the original terms of supervised release.
The probation office sought a modification. The government actually didn't really oppose, but said that they didn't think it was necessary. I don't think the court should read too much into whether probation thought that a modification or clarification was necessary. They have an interest in making sure that all the I's are dotted and T's are crossed.
But the
And
district court found that it was a modification or granted a modification, right?
right, the court also said that the court didn't think that it was really necessary. It was a clarification that the installation was heavily implied in the original condition. But it seems that everyone just kind of thought, what's the harm? And
Having treated it as a modification, why wouldn't it be covered by the appeal waiver?
if it's a true modification, we don't view it as a true modification. Even if it is introducing something slightly new, it's clearly contemplated by the original condition of supervised release.
Well, but so if we have a rule that says, if we were to decide that the appeal waiver bars this appeal, what about modifications that were more substantial?
That's a harder question. We're not pressing that argument. If it was an entirely new modification, whether the appeal
So you
waiver.
think an entirely new modification would not be covered by the appeal waiver?
Possibly, we haven't aired that argument fully. I think that is a hard question. Here, the appeal waiver is very broad and covers.
So what would be the rule then? The rule is like if the court feels like something is a clarification instead of a modification?
I think it,
Okay. I mean, you know, the district court said, I'm granting a modification. Use that term, it's a statutory term. So I feel like either modifications are covered by the appeal waiver or they're not covered by the appeal waiver, but I'm not sure how we're supposed to sort out like whether it was like substantial modification or not. That doesn't seem to have any statutory basis or any basis in the appeal waiver.
here, the original condition referred 3 times to the installation of monitoring software. This was part and parcel of the original condition. And if we get into a world where any sort of clarification is not covered by an appeal waiver, that could really gut appeal waivers' effectiveness and discourage probation or the court or even the government from agreeing to these clarifications, which doesn't seem to be in the interest of defendants.
Well, Mr. Smocks' counsel suggests that a clarification, you know, might be covered by the appeal waiver, but we don't have a clarification here. We have a modification or something that was labeled a modification.
We would ask the court to look at the substance over the form. Again, the original condition requires installation of monitoring software. It refers to that 3 times. The majority of the condition is about the monitoring software and making sure it's functioning effectively. It really can't reasonably be read any other way. And in light of case law that supervised release conditions are read in a common sense way, with the plain meaning, with the district court's intent in mind, in light of all of that, this is properly characterized as a clarification.
Is this monitoring software on 24 hours a day?
That's not in the record, but that's my understanding that it is.
And so what happens is how does probation utilize it?
I'm happy to answer the question. It's not in the record. My understanding from talking with probation is that it does have continuous monitoring, and then probation occasionally on a periodic basis will go in
They can
and
sit in
review
front of
that.
a screen here in Washington, DC, and monitor everything that's going on the computer. See,
I
the
suppose-
reason I'm asking this question is that the condition that was imposed was in 2 parts. This is after the original sentencing. And one was install this monitoring computer software. But the second was that it can't be used unless there's reasonable suspicion that there's a violation of a condition of supervision and that the computer or device contains evidence of that. Is that what's going on here? I mean, you have a constant monitoring, but you can't use it unless you have evidence, a reasonable suspicion that there's been a violation of the terms and conditions of the supervised release.
That's not how the conditions work. So the monitoring is an ongoing monitoring that probation can look at on a periodic basis. The reasonable search condition and probation and the court said
Isn't that a
it.
search?
Yes,
If they're monitoring all the time, then that's a search,
right,
right?
right.
But the next condition says you can only conduct the search if you have reasonable suspicion that there's evidence there.
That condition, as the court said, was aimed at ensuring that probation can search computers that are not reported to the probation office. And that's what probation said when they asked for that condition as well. The 2 conditions are aimed at different things.
I just don't understand how the 2 can stand together.
Also, that wasn't objected to below. So that argument is plain error. But again, the reasonable suspicion
Yeah,
searches.
but it sounds to me like a plain error.
Well, the reasonable suspicion searches are really aimed at computers that were not reported to probation. The monitoring is for the computers that are subject to the monitoring. There might be some overlap there, but they're not inconsistent.
So help me understand whether or not the district court thought that a modification was really needed. The fact of the matter is that we are reviewing an order that is saying that it is modifying the conditions of release. So why shouldn't we treat this? I mean, how can we just say this is a clarification and not a modification when the order says that it is a modification? What authority do you have for that proposition?
Looking at the substance of the court's original order and the substance of the later clarification, I point this court.
They're not necessarily different. A clarification can be a modification, can it? And a modification can be a clarification. I mean, well, you say, well, this is just a clarification. That does not exclude the distinct possibility that it was also a modification of the terms. This far and no further, or one exception or another, they're all clarifications, but they're also modifications, aren't they?
Well, in light of the original order that talks extensively about installation of monitoring software, that this condition was part and parcel of the original condition. And in Love, this court said that looked to the district court's intent in trying to parse out this distinction. And there was some discrepancy between the oral pronouncement of the court and the written judgment. And the court there said, we're not going to remand for the district court to do this over, where the written judgment was merely clarifying the original order. So under that analysis, there is a distinction, and the court is not bound by formalistic distinctions.
So let's suppose that you have a situation where the original judgment, is clear that installation of the software is permitted. And the way that this was worded is that the way that this judgment was worded, it just says computers subject to computer monitoring, but it didn't really define of like what computers those were. So let's suppose the defendant got a job in an office and there are 100 people and they all had computers, and probation said, well, we think that since you could access any of those 100 computers, we should be able to install this software on all of those 100 computers in the office for you to continue working there. And, you should notify these people that their computers are subject to monitoring, but essentially you have to allow that to happen or you can't continue working there, or we'll consider it a violation of your supervised release conditions for you to continue working there if we're not allowed to install the software. And the employer says, no, we're not going to let that happen. So we're going to have to let Mr. Smocks go. We'd love to have him stay, but we're just not going to allow probation to monitor all of our computers. Is that covered by a waiver? So Mr. Smocks says, the district court, he challenges that in the district court. The district court says, that's perfectly fine. That's a reasonable modification. You've waived everything. You're going to come here and you're going to say he's waived the right to appeal that.
But That's an extreme example. I do think that under the terms of the condition, it does cover computers that he uses. That doesn't strike me as a modification, but this court also does presume, and this is,
So it would be waived.
I believe so, but probation could always unreasonably implement conditions. There's a lot of discretion afforded to probation offices. And that works because courts assume and presume that that discretion will be exercised reasonably. And if he went back to the court and the court said that's what I ordered, then conceivably that would be waived. I don't know if the government would choose to enforce the appeal waiver in that instance, but that doesn't strike me as a modification under the language that we have here.
This order also applies not just to computers, does it? It's not just confined to computers.
It uses computers. It's defined. Computers are defined broadly under the statute, so it extends
Well,
off
yes,
cell phones.
statute, but it also says computers or other electronic communications. Now, it would seem to me that an electronic communication would include telephones and cell phones. And you have to allow, or the defendant has to allow searches of that. Does that mean that the probation office can put a wiretap on his phone and then and pull up whatever they want if they have some reasonable suspicion?
That's part of the computer search. That's not under the purview of the monitoring software, but
I know it's not computers. This is broader. It says or other electronic communications. What do you think that entails?
Right. I agree that that's broad. But that the burden there is higher. There has to be reasonable suspicion of a supervised release violation, and that's more along the lines of an ordinary search upon reasonable suspicion, which is permitted in the supervised release or probation context. But I agree that that is broad.
I don't, I guess, I'm not sure to, I guess, follow up on Judge Randolph's questions. What is the meaning of the word search in the modified order that's at A196?
As to how the search would actually be conducted?
Yeah, I mean, why search seems to be something that's different than just the installation of the monitoring software and the monitoring software just operating normally. Search seems to be something different than that. Am I misunderstanding this?
Again, this isn't exactly in the record. My understanding is that a search, it could be conducted, it could be a physical search looking through a computer. It could also be a search through forensic software that is installed on the computer, which is how searches are often done of electronic devices. But it's different than this ongoing monitoring condition that's in the original order.
So help me understand what the district court knew that it was ordering at the time that it made this modification or clarification. Help me understand what the district court, what was in the record that the district court knew like how this software would operate, what it would do, how probation would use it, et cetera.
The record shows that Smocks understood this software to be broad. He said that it would cover his third-party communications. He argued that he has a privacy interest in the contents of his devices, that it would monitor his private affairs. In his argument was that the monitoring software should not be imposed at all because that would violate his First Amendment rights and his general right to privacy. The court evaluated those arguments and rejected them. And that's why the court weighed monitoring software versus an alternative like a computer ban. But the intricacies of the monitoring wasn't directly raised. It seems if from the record, that everyone understood that this would be broad.
I mean, he says at one point in his pleading, right, this is going to monitor everything that I do on the internet, right? Doesn't he make that argument?
Yes.
And there's no kind of pushback on the other side that, no, that's not what the software does.
Correct.
So we should assume that that's what the software does.
I think that is supported by the record. It wasn't raised below, and under plain error.
What do you mean it wasn't raised below?
The intricacies of how the software worked, whether the district court was required to delve into the details of this. The argument was much more general than that, and under love and objection that's raised generally is not enough to put the court on notice of more specific arguments. And it wasn't plain or obvious that the court was required to get into those details, especially because courts often do delegate tasks to probation. For example, in the internet ban context, probation is allowed to decide exceptions to that. And here, the monitoring is not even preventing Smocks from doing anything. It's a
Didn't the
monitoring.
pre-sentence report itself equate computer monitoring with a search? The pre-sentence report says that.
Right. We agree that it's a search.
Oh, okay.
Right. Yeah. So under plain error review, at a minimum, the district court's delegation of this to the probation office was not an error.
So give me your best argument as to why, in this case, it would be appropriate for probation to have 24/7 monitoring ability of everything that this defendant does on his computer.
The underlying crime was transmitting threats using a computer. The computer was instrumentality of the crime, and the court recognized that he had used computers in the past to commit crimes. The court found that there was a need for deterrence, especially because at the original sentencing, Smocks did not exhibit remorse and had a history of supervised release conditions. And the court found continued deception. In light of all of that, the monitoring, the computer monitoring was reasonably related. And Smocks now on appeal is not actually challenging the monitoring itself. That was in the original order, which he's not challenging. It's more about how the monitoring is implemented.
Anything else?
No.
All right, thank you.
Thank you.
Ms. Wright, you were out of time, but we'll give you the, I think, 2 minutes you requested for rebuttal.
Thank you. To be clear, when I say that a clarification might be arguably covered by the waiver, I'm thinking of a situation where there's like almost like a clerical correction or clarification. That wasn't nothing substantive. I just want to be clear about that. Because I could see like it's like clerical corrections are different. And the fact is that here, before the order, before the modification, the software couldn't be installed, and afterwards it could. So it's clearly substantive. I want to point out the Rule 11 colloquy didn't actually incorporate in the waiver the quote conditions of supervised release, and the court has looked at that sort of thing as far as when it's construing the waiver and whether it's going to be construed against the drafter and how strictly. I'm not aware of an issue with defendants appealing a bunch of modifications in my 30 years at the FPD. I don't think I've ever seen one until this one. So it's not like something that's this giant gaping hole in the waiver that they couldn't possibly have meant to exclude that, because that would be such
what are we to take from the original judgment that's at A60 says, to ensure compliance with the computer monitoring condition, the defendant must allow probation officer to conduct initial and periodic unannounced searches of any computers subject to computer monitoring. And then it says that the searches shall be conducted to determine among other things, whether, I'm adding among other things, whether the computer contains any prohibited data prior to installation of the monitoring software. So what else could that mean other than monitoring software is going to be installed as part of this condition?
I guess it could mean like if you were subject to installation, and it's possible that, you know, there are like conditions that don't always necessarily apply in every respect to a person. So if you're standing there hearing this be read and you're saying this is to ensure compliance with the community monitoring condition, you could be thinking, well, she hasn't imposed a computer monitoring condition, so this stuff is just like boilerplate. I guess that's what I would say.
The condition in the second go-round that you can't conduct the search probation off unless you have reasonable suspicion. That's actually favorable to your client, isn't it? You're not attacking that, are you?
Right. I mean, but it does show the nonsensical nature of the conditions as a whole, and I think that's relevant to whether the court could weigh it. That's the kind of the point. If it doesn't make sense, how could it have been properly weighed, the deprivation against the, if it's not clear what it even means. And I just want to say one more thing, the Volcker case, you know, this is really analogous to it's impossible to evaluate the minor contact ban when the limits on the ban aren't clear. Just want to say one more thing about, just going a little more about the scope of the waiver. Sorry, that here, you know, that we obviously have the circuit courts that have said it doesn't cover this, but if you look at the waiver itself, paragraph D waives the right to appeal the sentence, quote, imposed. And it seems to me that it's clear that it's talking about an appeal. The appeal is a waiver of a direct appeal because it excludes appeal on the basis of ineffective assistance of counsel. And then it has a separate subsection excluding ineffective assistance of counsel from waiver under 2255 collateral attack. So the fact that they put that in there twice, it seems like that first paragraph has got to be referring to the direct appeal. And if an appeal of a modification of the sentence imposed was forbidden, it would say so. But really, this is clearly directed to the, you know, the appeal that you're about to make, that you would have to make within the 14 days of the judgment. And I think the court said this was limited, but there was no limit. Just on the preservation, that Mr. Smocks objected to the breadth, and the breadth that put the court on notice that there was a need to limit it. And the court said it was limiting it, but there was no limit at all. The search was limited. There had to be reasonable suspicion. It had to be a reasonable time and manner, but the monitoring had no limit. And the last point is that the government says the computer is the instrumentality of the crime, and that's why we get to look all through it 24/7, I guess. But if the threat had been over the phone, could there be a wiretap to just listen to everything he says over the phone? And Melania made that point when it said that if the defendant in that case had met his trafficking victim through a classified ad in the paper, could you ban him from reading all newspapers? So we would say that's analogous and ask the court to vacate the condition and remand for a balancing under 3583D.
Thank you, Ms. Wright.
Thank you.
We'll take the case under submission.
Case number 23-1750. Jose Vasquez, appellant versus District of Columbia, and Ruben Agosto, officer, individually and in his capacity as an employee of the District of Columbia. Mr. Magid for the appellant, Mr. Law for the appellees.
Mr. Majid?
Your Honor, may I reserve 2 minutes of argument for rebuttal, please?
Certainly.
May it please the court. Primary issue in this case is whether a police officer, and more broadly, the Metropolitan Police Department or any police agency, they escape liability by ignoring clear exculpatory evidence. My client, Jose Vasquez, was arrested on a warrant issued by Will County, Illinois, that named a different Jose Vasquez with a different social security number. MPD ignored the difference between the social security numbers, beginning with an arrest in October of 2016, and incarcerated him. Officer Ruben Augusto took it upon himself to send fingerprints and a photograph of Mr. Vasquez to Will County, and less than 3 hours later got the response at the teletype room, which is where the responses typically go at MPD headquarters, that said, do not, the person you're holding is not the person we want, release him. Now, there's been no explanation from MPD what happened to that notice, but it's clear that Officer Augusto didn't do any follow-up. He said his job was done, in his view, when he sent the message. And although he acknowledged that he was undertaking to determine whether Mr. Vasquez was in fact the person who was sought by Will County, he apparently thought that the answer to that was unimportant.
Now, whether or not that was a false imprisonment isn't before us, right? It's only the 2017 incident.
That's correct. This is the summary judgment that was granted previously. So the issue that went to trial was the false imprisonment claim, Your Honor.
And you're not appealing the granting of summary judgment on the liability with respect to the 2016 incident?
Oh, we absolutely are, Your Honor. Yeah.
On the false imprisonment tort, or on the constitutional?
On the constitutional argument, Your Honor.
Yes, but not.
Okay. Yes, you're right, Your Honor.
I'm just trying to make sure.
Yeah, I misspoke myself, Your Honor. I apologize. Yeah. So the explanation is Officer Augusto says, well, I didn't think it was my job. I thought it was the officer who did the initial check on the NCIC database. That officer said, no, that isn't my job. My job is only to do the initial check. The teletype room says it's absolutely Officer Augusto's responsibility, because it's the person who sends the request to the foreign jurisdiction who is responsible for getting the response. And then it turns out that it's Officer Augusto who on November 3rd is the person who transmits this information when the U.S. Attorney's Office asked for it. So he's got it this whole time. And the argument the district made and that the district court accepted was that it was not, there was not clear law for Officer Augusto to follow that said that it was wrongful to ignore the clear statement from Will County that says, release this guy. And he's then held for another 6 days.
Are there any police regulations, or is there any law requiring them, the police, to make inquiry of the police in the jurisdiction that issued the warrant?
That is what MPD practices, whether it's a written policy, I don't know if it is, but MPD says that when there is a question as to whether the person is the right person incarcerated, they inquire of the foreign jurisdiction.
When there's a question.
Right.
What if they're certain they don't have to make inquiry?
So that's a broader issue. So apparently what MPD does, if there is no question raised, if someone comes in, they run a very cursory check in the NCIC database to say, is there a person with the same name and birth date? And they stop there, which then goes to our Monell claims, which is, what about people who have very common names like Jose Vasquez, who tell you, I'm not the person arrested. In fact, I have been cleared before by courts. You have a photograph and fingerprints of the person who really is wanted. That's not me. And there is a clear statement in the NCIC record that says, do not arrest the Jose Vasquez with my client's social security number. All that's ignored. So that gets to a broader policy issue on the part of the District of Columbia, which is what makes this case so perplexing is, on the one hand, you say, well, there's no firm policy to follow up. And that is precisely the problem when you see that over time, repeatedly, it is not uncommon for the wrong person with the same name to be picked up, and there's no clear means within MPD of dealing with that situation. But the immediate claim against Officer Augusto is, he is affirmatively undertaking, and he admits that the reason for that is to determine if they've got the right guy. And Sergeant Mack, who's in charge of the fugitive unit, says, yeah, it's important to us to find out because we don't want to detain people who are not the person wanted in the warrant.
Now, you cited below a case called Sanders.
Right.
That where the DC Court of Appeals in the Fourth Amendment context said that should doubt arise as to the identity of the subject of the warrant, then the police have basically an obligation to make immediate reasonable efforts to confirm or deny whether this warrant applies to this individual. Is that the clearly applicable law to defeat qualified immunity, or what other cases can you point to?
Yeah, there is strangely a paucity of case law on this precise situation. But yes, although Saunders was in a somewhat different context, it does state the applicable law in our view, which is if you're confronted not just with a single protest of innocence, because I'm sure many prisoners protest innocence and say, I'm not the guy. But if you're not only confronted with all kinds of evidence it's not the right person, it's clear in the NCIC report that it is not, that the person is not being arrested under a valid warrant because it names somebody else. And you undertake to find out if that person is the person sought in the warrant, and then just ignore the result and incarcerate a person, that is a clear violation of liberty interest. Should I turn to the Monell claims, Your Honor, or Your Honors?
It's your time.
Okay. Very briefly on the Monell argument. Again, the argument that the district has made and that the district court embraced was, well, there can't be, when you talk about a policy, there has to be a clear constitutional violation in the past. Otherwise, the fact that there's been a failure to train or a failure to have a clear policy can't give rise to a claim under 1983, and that's not the law. This court in Hurd and in Baker made it clear that it was the risk of a constitutional violation that was the issue. And here, where we've shown that 10 times a month, the District of Columbia or the Metropolitan Police Department itself confesses that it has miscommunication with its teletype room, which causes delays in providing evidence to the U.S. Attorney's Office, when there is evidence that that it is not uncommon for people with very similar names to be arrested and they turn out not to be the right person. It was all but inevitable that something like this was going to happen if you don't have any kind of clear procedure for what happens when you send a teletype message. Who is to receive it? What are you to do? There's no clear procedure about checking social security numbers. Yes, it's true that somebody could fake a social security number.
Ask you about the false imprisonment finding by the jury.
Yeah.
So there you say that in part that can rest on collective knowledge, which of course is a Fourth Amendment, concept drawn from the Fourth Amendment
Correct.
Case law. So I was wondering, are you aware of any DC case that applies collective knowledge in the false imprisonment context?
Your Honor,
Obviously the federal court's sitting in diversity and, we're not free to innovate new law. We have to look at the law of the district. So are you aware of any case?
I'm not. This is an issue of first impression, as far as I'm aware, in the district. The District of Columbia refers to the Curry case, but that's quite different. It doesn't address this issue. Curry is an issue where somebody was in a Giant store, apparently went to the pharmacy, and then put a slab of beef under his jacket.
So there's no case, though, that says this concept applies in this context.
No, there isn't. But there is law because the district itself advocates for it. Their argument is that it's perfectly fine, and their excuse in 2017 is that it was perfectly fine to continue detaining plaintiff Vasquez because they could rely on what the Secret Service told them. So they're saying that despite all of the evidence that this wasn't the right person, they could rely on another law enforcement agency. So they are, which is not to the fugitive squad, but to the people at the precinct. So they're using this kind of collective knowledge as a defense, and the door swings both ways.
So you didn't cite it in your brief. I'm going to ask your friend on the other side about a case called Marshall versus District of Columbia at 391 A. 2nd, 1374. And the pin site is 1381. But there, the DC Court of Appeals, in a false imprisonment case, said that an officer is imputed to have constructive knowledge. So it didn't use the term collective knowledge, which is kind of a term of art in the Fourth Amendment context, but it used the term constructive knowledge. And then the parties cited a case called Scott, and that case is bandied about. And Scott cites a DC Court of Appeals case called Woodward, which is 387 A. 2nd, 726. And Woodward says in the false imprisonment context that if there's notice of a potential invalidity there, the warrant was invalid because it was stale. And under DC law, then it was invalid because it was over a year old. So that was the defect, but basically it stands for the proposition if there's notice that there's a problem, then you have a duty to investigate, which is the same thing that Sanders says, which is in the Fourth Amendment context. And Scott cites, which is a false imprisonment case, cites Sanders, even though it's a Fourth Amendment case. So I don't know that the DC Court of Appeals sees the Fourth Amendment kind of false arrest context any differently than the common law false arrest context. Do you disagree with any of that?
I don't disagree. I'll say that I'm embarrassed that I didn't cite the cases, Your Honor. But no, I don't disagree.
What is your, the district court said that it was granting judgment notwithstanding the verdict because it basically agreed with the district's argument that there was no duty to investigate the discrepancy of Social Security numbers. You obviously disagree. Why should we reverse that rule?
Well, because you have a situation in which Mr. Vasquez tells MPD, I was just here 4 months ago. We went through this whole exercise before. You look at the photograph, you can tell the guy with the tattoos that's wanted in Illinois is not me. The fingerprints don't match. And I was released previously. Go look at the file. MPD has before it, the Social Security numbers don't match. They have available to it all the files and all the rest. And the duty, you know, the officer just says, yeah, I looked at these and the Social Security numbers were different, but essentially I just chose to ignore that. And for the reasons you just cited, Your Honor, that's not permissible. You can't just turn a blind eye to exonerating evidence and say, therefore, I'm in the clear.
So he was confined in the second arrest for 5 hours, is that?
No, he was actually confined overnight and then through the following afternoon. The district court tried to characterize it as saying, well, really the only period is 5 hours because that's when the officer who Rollins, yes, thank you, Your Honor. When Officer Rollins then went out and made out the affidavit to the court representing that this was the person wanted, notwithstanding the discrepancy in social security numbers. But for the same reason, when Mr. Vasquez is protesting all of this upon arrest, this really is imputed for a longer period of time, not just at the
Both
time
of
of arrest.
these arrests were for traffic violations?
They were, Your Honor. I mean, one was, I think, failing to signal a turn. The other was broken tail light.
Was the car impounded?
I don't know, Your Honor. I know he was.
All right, we'll give you a couple minutes on rebuttal.
Thank you, Your Honors.
We'll hear from the District of Columbia, Mr. Lowe.
Good morning, Your Honors. May it please the court. Richard Love for the District of Columbia and Officer Augusto. If I could start with the facts relevant to Officer Augusto. Officer Augusto was not the arresting officer, and he was not the fugitive unit officer who was responsible for the case and responsible for checking with Will County as to whether the warrant was still active and that they would extradite. Indeed, he didn't have any contact with the case until 5 days after Mr. Vasquez was arraigned in court. And that was because on that day, he happened to answer the phone when there was a call either from the U.S. Attorney's Office or Will County, he could not recollect which, for him to send a photo and fingerprints to Will County. He emailed those fingerprints and photo to email to Will County. He also testified that, or this testimony that the fugitive unit goes up to the teletype office to pick up messages in their inbox at least twice a day, that the response would not have been delivered to him because he wasn't the officer from the fugitive unit whose case this was. And the teletype, which is how Will County responded, they didn't respond by an email reply back to Officer Augusto. Their teletype instead said, "Attention, warrant/fugitive squad." Now, under those circumstances, there's no case that indicates that emailing a photo and fingerprints created an ongoing obligation under the Fourth Amendment for Augusto to personally monitor Will County's response. Indeed, I would submit the case law is to the contrary. If you look at the Supreme Court case of Baker v. McConnell, there the court clearly said, indeed, an office official charged with maintaining custody of the accused named in a warrant has no constitutional duty to perform an error-free claim investigation of a claim of innocence. And I think this case is very close to Baker v. McConnell. They both dealt with mistaken identities or individuals that are arrested on a valid warrant, but the identity is mistaken. There, it was the wrong McConnell brother in Baker, and here you have the wrong Vasquez. And the period of time that they're held is very similar, 3 days for Mr. McConnell, and here it was 5 days subsequent to Officer Augusto's email.
I don't want to pre-terminate this if my colleagues have questions about the constitutional claims. I'd really like to hear from you about the ruling on the false imprisonment, particularly given the district court had the crux of the district court's ruling granting the JNOV was that Rollins had no duty and acted completely reasonably to do nothing more after noticing the discrepancy of the Social Security numbers. And I don't see how that comports with the law of the District of Columbia in Woodward or this Mitchell case, where it says that once the police are essentially on inquiry notice, they have to inquire. in the false imprisonment context. So help me understand why it was an error for the judge to grant the motion if that's the DC law.
Well, I'm not familiar, and it wasn't cited in the case with Marshall or.
But the argument was made.
The
We
argument,
have to get the law right. You know, we can't make arguments for parties, but if the argument is made, we have to correctly apply the law that applies to that argument. Do you agree?
sure, I'm just indicating I'm not familiar with the two cases, so I can't really respond. I am familiar with Scott, and we did cite that in our brief, because in Scott, where an officer had suspicion that they were holding the wrong individual, the DC Court of Appeals ruled that wasn't sufficient, and they affirmed a judgment for the district in, I believe, a false imprisonment context. But if I could address your question, Your Honor, in both factually and legally. So factually, the only evidence that was that didn't match was the Social Security number. Every other indicia of identification here matched.
Photos didn't match.
Excuse me.
Fingerprints didn't match.
The photo did match in 2017. The photo absolutely did match, Your Honor. Officer Rollins testified that he relied on the
Well, he
Secret
relied on what
Services.
the Secret Service told him.
Well, it's in the arrest report. And officers, we have testimony from Sergeant Mack, as well as from Officer Rollins, that's what they rely on, because that is the report of the circumstances under which the arrest occurred. It provides the only details that the fugitive unit uses and relies on. It establishes the probable cause for here Mr. Vasquez's arrest. There was no contrary testimony that was unreasonable rely on the Secret Service's report of a photographic confirmation. It indicated they received a photo from Will County and that it matched the subject that they had arrested. He also has the NCIC confirmation, which is the names.
Are the photographs in the appendix?
The photograph that Secret Service reported having received is not in the record. Just the Secret Service, the arrest report itself is, but it was
But not to compare. So we can't look at them and learn whether or decide whether they match, as you just said. Is that right?
Not the photo that Secret Service says they compared. That's not in the record. But Officer Rollins clearly testified that he relied on that photographic confirmation. That was a part of his consideration as to whether the correct individual was in custody. But he also relied, it was the same exact name, it was the same exact birthday, and the physical description matched. So the only indication.
The Secret Service, what, did the Secret Service agent testify?
Testify in the trial?
Yeah.
No, he did not. And either side obviously could have called him, but he was not
Is there any
called.
objection to the testimony by Rollins that it was hearsay?
Yes, Your Honor, it was an objection that it was hearsay and it wasn't admitted for the truth.
It was not admitted.
District.
So you're arguing it for the truth to us.
No, I'm arguing it just as it was admitted into evidence, which is the state of mind for Officer Rollins. Officer Rollins' state of mind in terms of why he did what he did. And that
Well,
was.
you just argued that the photos matched, and that would.
Well, that's what
that would be using it for the truth.
No, I'm using it. That's what Officer Rollins read, that there was a photographic confirmation. That was his understanding of the facts as to why he proceeded to develop.
So you say you're not familiar with Woodward, and I take that. But Woodward says that if there were the police officers were on notice of a potential invalidity with the warrant, the court says at a minimum, the officers were required, quote, to investigate in order to determine the status of the warrant itself before going further. And then they go on to say the failure to investigate would be, open quote, a dereliction of duty, close quote. That's how it describes the law of false imprisonment. If that's the law, how is the judgment here, the jury verdict here, against the weight of the evidence?
Because I think, as the district court probably found, that we have evidence in the record from multiple people, Officer Rollins, Sergeant Mack, as to the differing Social Security numbers, that individuals often manipulate their Social Security number, that it's not a red flag, it's not a disqualifier. And Officer Rollins explained why he didn't believe that the differing Social Security numbers was something that needed to be followed up on in light of the matching information from the NCIC data, the birth date.
Why would it be unreasonable for jurors to feel different? I mean, the issue here isn't whether the juror could reasonably conclude, okay, yeah, maybe that's not a dereliction of duty. The issue is it unreasonable? Could no rational jury find that to be a dereliction of duty?
Well, I would go back to the instruction that the court properly gave, and is from Curry, and Curry clearly says it's the law of the District of Columbia. And that is that the officer had to undoubtedly have learned that Vasquez was undoubtedly not the subject of the Will County warrant. And there's simply no evidence that points
that kind of begs the question. That is the ultimate finding, but if you have a duty to investigate, and if you had just simply looked 2 minutes further into the file and you would have found a document that in bold letters said, don't arrest this man, he's not the guy.
Mm-hmm.
At that point, if he had seen that, do you agree that he would undoubtedly have known that
Sure, of course, Your Honor, but.
Okay, so then if there is a duty to investigate, how is it, under these facts, how would it be irrational for a jury to say he had no duty to inquire further when he saw that there were different Social Security numbers?
Well, I don't think there was, one, this isn't a negligence case. Two, he had no duty because, as he explained, a Social Security number is not disqualifying, it's not a red flag, and he had abundant evidence from which he resolutely believed that that the Vasquez they had in custody was the correct individual.
I mean, is there some distinction in what duty is required when the original arrest is valid?
Yeah, I think.
Continuing custody, because I'm also not familiar with this Woodward case, but that seems to be a situation in which the arrest was not based on, where the arrest was not properly supported.
I think there's an absolute difference. I mean, here, there's no question there was probable cause to arrest Mr. Vasquez. Right. He doesn't challenge that on appeal. Is there a different standard for the continuing custody after arrest? Yeah, and I think that's where the instruction comes in. That's why, again, you look at Baker, the Supreme Court says, and I understand it's in a constitutional context, that they don't have to perform an error-free investigation.
So,
But-
so how can you use the Fourth Amendment cases when they help you to, in the tort context, but say that appellant can't use the Fourth Amendment cases when they help him in the Fourth Amendment context?
Well, as I said, I acknowledge it's the Fourth Amendment context. That's why I mentioned that, and I'm not trying to rely on that. I think more directly, I'm relying on the instruction, which is dramatically different from an instruction that would be at issue if this was a challenge to probable cause, whether or not there was an objective basis that there was facts that supported criminal activity.
So you think that it's different, so that if at the moment that he's arrested, he says, look, I've been through this drill before. I have a different social security number than the guy that they're looking for in Will County. And those had been the facts. You think that the DC law Woodward would mean that, okay, they have a duty to inquire at that point, but if they've had him in custody and he makes that claim, and they believe that they had probable cause when they arrested him, they don't have a duty to inquire just because they had probable cause at the time that they arrested him? I mean, what's the kind of logic behind you have a duty to inquire at the moment of arrest versus later?
Well, again, I think, what the DC Court of Appeals recognized as the law in the District of Columbia relevant to false imprisonment is articulated in the Curry case. And the standard there is that the officer has to undoubtedly, and here, there was no communication to Officer Rollins. Officer Rollins never spoke to Mr. Vasquez. He never knew that he protested at Second D. That's the evidence. All he knew was that the paperwork showed that this individual matched the name, birth date, physical description on the NCIC report, and he had photographic confirmation from the Secret Service arrest report. That's what he knew, and he acknowledged.
He knew that their social security number didn't match.
He did. And he explained why he did not believe that was disqualifying.
Why would it be irrational for a jury to just reject his explanation and his rationalizing of why he didn't have to do anything further?
Well, I think the court gave an example or referenced the example in the instruction from the restatement that he, and the illustration in the restatement is.
So if the jury has facts that are different than one of the illustrations in the restatement, then they've acted rationally, irrationally?
No, I'm trying to explain that I believe that in light of all the evidence, the mere difference in social security number was not sufficient for a reasonable jury to conclude that Officer Rollins undoubtedly knew that Mr. Vasquez was not the person wanted in Will County.
So on the remitter, one of the grounds that the district court relied on was the fact that the jury had found in the district's favor on malicious prosecution. And the district court said that it couldn't reconcile finding in favor of the district on that count, and then finding against the District of Columbia on false imprisonment. But malicious prosecution requires proof of malice and false imprisonment doesn't, right?
Right, but it also requires an absence of probable cause and recklessness or
So you
malice.
could reconcile this by saying that the jury found that there was an absence of probable cause, but no malice. And that's why they rendered a verdict for the district in the malicious prosecution. But they found an absence of probable cause and in the district and proof that they knew that this wasn't the right person. And that's why they find in favor of him on false imprisonment. There's nothing, what's contradictory based on the elements of those offenses?
Well, I concede, the jury could have found, a possible one without the other that would be less supportive of what the district court cited the differing judgments for. But I don't think the district court relied on simply the malicious prosecution judgment, nor are we. I think
But
the court
he said that was
further confirmation.
that was part of what he relied on. And if that was part of what he relied on and that was an error of law, isn't that an abuse of discretion?
Well, I think he cited that for the judgment, not with the judgment as a matter of law. I don't think he cited it for
That's
the
true.
the
So
remitted.
I think I misspoke. He didn't cite it with the remitted.
Again, no, I think it's, you would look at, his ruling in its totality. It's very clear. It's very clear that at the end, he says, and he thought that the judgment on the malicious prosecution provided further support for his ruling that no reasonable juror could have found on the evidence that was submitted to it, that Officer Rawlins undoubtedly knew that Vasquez was the wrong person. And I think the court certainly was free to and could have construed that verdict as supporting that decision. Yes, perhaps it could be construed differently, but I don't think he abused his discretion by citing to that, and again, he didn't rely on that. That wasn't his primary reason.
Let me ask you a question about collective knowledge and the collective knowledge doctrine.
Yeah, sure.
I happen to know a little bit about it because I lost the collective knowledge case 30-some years ago when I was a public defender. But that case, in re MEB, the DC Court of Appeals held in the Fourth Amendment context that you could use the corporate knowledge of the police department, even items that weren't communicated from one officer to the arresting officer. You could add all of that up to constitute probable cause or reasonable suspicion. And it rejected a rule explicitly from the Supreme Court that Supreme Court had mentioned in a case called US v. Hensley,
Right.
that suggested, which is discussed and cited in the papers, which suggests that it's got to be communicated, because you rely on Hensley to say that you can't impute knowledge to Officer Rawlins. But the DC Court of Appeals says, well, no, we're adopting a rule broader than Hensley here in re MEB, which is 638 a second, 1123, decided in 1993. So if that's the law in the Fourth Amendment context, why isn't sauce for the goose, sauce for the gander? why isn't the knowledge imputed to Officer Rollins that's in the NCIC report? I'm sorry, that's in the justice file.
I understand.
Why doesn't it make sense to use it in that fashion?
Well,
Why is it a one-way ratchet?
well, two reasons. I think that I'm not familiar with NMED, but I was able to find, and no case was cited that holds that probable cause can be created or defeated by aggregating, the collective knowledge of officers who have neither communicated nor collaborated and are merely members of the same law enforcement unit. And I would point the court, we referenced it in our brief, but I'd like to elaborate a little bit on it, is the Gorham case. I know it's certainly not binding on the court, but I think its analysis is instructive because it deals with the scope of the collective knowledge doctrine and analyzes cases from this circuit and from several other circuits. And it explains why it would not extend the collective knowledge doctrine to encompass cases in which no actual communication or direction occurs between the officer conducting the search or seizure and the officer in possession of the information giving rise to the requisite reasonable suspicion and where the relevant facts are merely aggregated after the fact. And I think that's what I don't think the collective knowledge doctrine can be expanded to impute to Officer Rollins information that was never communicated to him by any other officer or that simply existed in MPD files that he was unaware of. The other point in terms of kind of like the goose, what's good for the goose is good for the gander. I think if you look at Ramirez and the cases it cites, like Whitley and the other cases, I
hear what you're saying, but the law in the District of Columbia is in re MEB, and it says that the corporate information available at the time that the officers effectuate a stop or an arrest or a detention is what is to be considered.
Well, again, I think, there is a difference between the initial arrest on a probable cause standard and whether there's an objective basis to do that, and whether or not maintaining someone in detention in a false imprisonment case are different for the reasons I've kind of said. But the other point that I was going to make, Your Honor, if I could, is that in Ramirez and Whitley, the cases that are cited in Ramirez, they found that, an officer can act on a warrant or a police communication from another agency or officer to arrest an individual, even if they don't know personally the particulars that have been communicated to him. But if the warrant turns out to be wrong, the arrest is invalid, as is the search, the fruits of that search. But none of those cases questioned the reasonableness of the arresting officer's reliance on that information. And I think that's similar here. I mean, in all those collective knowledge cases, they acknowledge the officer can reasonably rely on that information. And here, Officer Rollins reasonably relied on the information that was presented to him to maintain a custody of Mr. Vasquez. And it's a far cry from that to jumping to the evidence that would need to support a finding.
So let's suppose in this case, Officer Rollins mentioned to another officer, this guy says that he's not the one because he has a different social security number. Isn't that, we hear that all the time. and the other officer, looks at justice and sees that it's really not the same person, but just kind of laughs and says, well, we'll let this guy sit a couple of days and somebody will figure it out eventually. And he never does anything about it. So he doesn't tell Officer Rollins. So under your theory of what the law is, Mr. Vasquez loses if those are the facts?
Well, I think in the false imprisonment context, and as the jury was instructed in this case, it really rose and fall on Officer Rollins' subjective belief, and the evidence here is that.
So his subjective belief doesn't require him to investigate, and also it's immaterial if another officer investigates and finds out that Vasquez is exonerated, but doesn't do anything with it. But as long as it's not communicated to Rollins, no liability for the district. That's the outcome.
I believe so, Your Honor. And I think, he's not left with options. I mean, there may well be the basis for a negligence claim, but I think in the false imprisonment context where there needs to be evidence that the person being held is, there's knowledge that the person being held is undoubtedly the wrong person. Here, that has to be, Officer Rollins is the only person here in that scenario.
So they can do nothing to try to obtain knowledge when they are on inquiry notice, and we're not going to impute knowledge when somebody else knows it, just as long as the person that gets sued doesn't have the knowledge, the district evades liability.
Well, I think in these facts, there wasn't inquiry notice because of the abundance of evidence that confirmed his identity and the unreliability of Social Security numbers, as was explained in the evidence and the testimony of various
We've had
officers.
an abundance of cases cited to us, but we do our own research and we find other cases that appear to be on point and that appear to say something kind of so like we don't have any duty, just because you cited to us a bunch of other cases, we don't have any inquiry notice or duty to look for other cases. I mean, I don't see how that's how inquiry notice works. It's just because either something rises to the level of giving you some sort of duty to investigate or it doesn't.
I'm not arguing to the contrary. I'm saying here the facts didn't trigger the Social Security number alone didn't trigger a further duty to investigate, given the testimony and given the evidence that there was a matching name, a matching birth date, a matching physical description, and photographic confirmation.
All right. Any other questions? All right. Thank you.
Thank you.
All right. We'll give you 2 minutes on rebuttal.
Unless the panel has questions, and I am happy to answer those, I'll waive my.
All right. Thank you. We'll take the matter under
All
submission.
right. Thank you, Your Honors.
Case number 22-5221, Elizabeth Schacht, MD, appellant versus Stephen L. Lieberman in his official capacity as acting principal undersecretary for health, Department of Veterans Affairs, Veterans Health Administration et al. Mr. Arnold for the appellant, Mr. Brewer for the appellees.
Good morning, Mr. Arnold.
Good morning, and may it please the court. Brandon Arnold for appellant, Dr. Elizabeth Schacht. I'd like to reserve 3 minutes for rebuttal. The district court erred here because it upheld an action by the VA's Disciplinary Appeals Board based on reasons that the board only supplied years after it took the action. It's a bedrock principle of administrative law that the agency has to provide a reason when it acts, and that the court can only uphold an agency's action based on the reasons supplied at that time. The board here did not do that. In the original administrative record, there is no reason whatsoever given for why the board summarily excluded a large swath of the evidence submitted by my client.
But Mr. Arnold, was a remand even necessary here in this case? I mean, you know, if you compare like administrative proceedings to district court proceedings, there were often evidentiary rulings without any statement in the record about why that ruling was made. And if there's no objection made at the time, then an appeals court can uphold the evidentiary ruling for any reason that's apparent in the record. So, you know, so the district judge here was being very conscientious in terms of remanding for further explanation, but I mean, I don't even see that a remand was necessary in this case. And if there had been no remand, then all these arguments about the Regents case, I think, just wouldn't apply.
So I think the key distinction here is that we're dealing with an agency and not a trial court. As you say, if this was in the trial court, the judgment could be upheld for any reason, including reasons not given by the court below, as long as it fit with the record. But trial courts aren't bound by Chenery. And so the issue here—
But an evidentiary ruling isn't a final agency action. I mean, it's reviewable, of course, because it's now part of a final agency action. But I mean, I think your argument sort of relies on making this evidentiary ruling some kind of standalone agency action to which, you know, all of these doctrines apply. And I'm just not sure that an agency's evidentiary ruling should be viewed that way.
So I believe even in the evidentiary rulings, the agency needs to provide a reason why it's excluding evidence. And often that reason can be quite terse. It need not provide a lengthy reason. If, for example, the agency had stood up when this evidence was admitted and said, we object on basis because it's untimely. If the chair said sustained, that would be a sufficient reason. But that's not what happened here. So in this case, the appellant submitted the evidence.
What happened here is that there was a kind of deadlines that were set. And then after a deadline, both sides tried to submit evidence after the deadline, and both sides were rejected. So why can't we just discern from the record that the reason that it was rejected was because it was after the deadline?
Well, so let me back up on the deadline. I don't think it is clear that there was fair notice of a deadline in the administrative record. The scheduling order that was put out by the board set a deadline for motions and other requests, but nowhere in that scheduling order.
Arguing that there's not notice is different than, I mean, that doesn't meet the hypothetical, which is that if the agency, if the body believed that it had set a deadline that was an operative deadline, and then these two submissions came after that deadline, and it rejected them for that reason, then that's the reason.
I grant that if the agency had set a clear deadline and given the parties fair notice of that deadline.
What was unclear about it?
It was unclear because it never mentioned exhibits at all. All it said was
requests, right? And when your client submitted the 200 and some pages, how did your client characterize that?
So she submitted exhibits, and in the cover email, her counsel said that he requested that the board admit them into evidence.
Right. So what's unclear about that? All requests have to be in by such and such a date, and the 200 and some pages says, here's our request. The only problem is it's a month late.
Respectfully, Your Honor, that's not how clear the scheduling order was. It said motions or other requests. There's no mention at all of exhibits. And the only place evidentiary submissions are mentioned at all in the scheduling order is to state that evidence can be introduced at the hearing itself.
After the board denied the request on that Monday, did counsel for your client object?
So after the evidence was excluded, counsel for appellant gave a proffer as to why the evidence was relevant and should be admitted. He did not formally use the word object, but he provided a rationale.
Did he ask the board for an explanation?
He did not, Your Honor.
And that would be fatal if he were in a trial court.
Well,
He
it would.
couldn't bring it up on appeal if he never even asked for a clarification. So that raises the question that my colleague mentioned, that why should an administrative board composed of doctors be held to a higher standard than a U.S. district judge would have been?
Well, the board, its only standard is to provide a rationale, which it did not do. It's
Which
simply,
you didn't ask for.
It's correct that appellant's counsel did not specifically request a rationale when the evidence was excluded, but submit that it was not his duty to ask for one. The board took action without ever explaining itself. It's the board's duty to explain its actions, not counsel's duty to force an explanation from the board. And going back to the
That would
evidentiary.
create a body of law that's totally foreign to the way trials are handled. I think not only in the federal district courts, but also in the state trial courts.
So I don't disagree that the rules are different, given that we're an administrative agency and not a trial court.
I mean, to follow up on Judge Randolph's question, in a trial, oftentimes the lawyer who objects to evidence just says objection and doesn't even say hearsay or relevance or asked and answered or anything else. They just say objection. And the judge says sustained. What is the reasoning there that we have on appeal to review?
Well, the appeal standard allows more leniency because the trial court decision can be upheld on any reason supported by the record. It doesn't matter. The district court didn't provide a reason at the time. But again, we're not dealing with a trial court here. We're dealing with an agency that has to provide a reason. It doesn't have to be a long reason. One word could be sufficient, but it has to say something. And it's telling here that when the evidence was sought to be admitted, the agency responded by objecting to some, but not all of it.
What is your best case for the agency having to give a reason when it excludes evidence in the course of an adjudicatory proceeding?
So I don't have a case that speaks to that directly. I am reasoning from Regents and from this court's decision in End Citizens United. And then the court has a body of case law making clear that evidence can be excluded based on a deadline, so long as the administrative agency provides fair notice of that deadline. And I think the case law, the General Electric's case, makes clear that one thing to consider when asking whether fair notice had been given is whether other components of the same agency understood the rule differently. And here you have the VA, which is a repeat player in these adjudications, that didn't understand evidence to be untimely. The VA sought to admit evidence on the exact same date without any recognition that it was untimely. And when the board itself.
What do you mean without any recognition that it was untimely? Where is it in the record that they didn't think that it was untimely?
There's nothing in their submission.
Just because they submitted it?
Well, and they didn't say this is untimely, but we're seeking leave to file. There's nothing in the submission that makes it clear.
Lawyers file stuff late every day. And it's not because they don't know that there is a deadline. They just, seek the grace of the court.
Right. Normally lawyers seek leave from the court to make late submissions. Here, there's no recognition by the agency that we're filing something late and we're requesting leave. And in the pre-hearing conference that the board held, they walked through various exhibits that had been attached to motions and admitted the exhibits that were attached to motions, even though only one of those submissions was filed before the October 7th deadline. They admit 7 or 8 different pieces of evidence, and almost all of them come after that deadline. There's not one word in the scheduling conference that says, we understand that almost everything we're admitting here is late, but we say it's not too late. This is okay, but not too late.
Okay, but that argument wasn't made in the agency proceedings, right?
The argument wasn't made in the agency proceedings because the evidence wasn't excluded until late in the process. There was never a cause to say we're challenging the deadline because the deadline was never articulated. At no point did the board say we're excluding this evidence because it's too late.
All I'm saying is that counsel never said in the agency proceedings, board, you have acted inconsistently with respect to what evidence you're allowing in and what evidence you're not based on, deadlines, right?
I agree. The counsel never said that, but the reason why counsel never said that is he didn't have reason to think the evidence was being excluded based on a deadline. All of
He
the
didn't know. I mean, there was no explanation given. So why not ask for clarification?
I think it would have been cleaner had he asked for a clarification, but it is the board's duty.
Mr. Arnold, what sort of rule would this be that every time in a relatively informal agency adjudication, the board or the adjudicator has to, on the record, explain every, interlocutory, decision along the way? And if not, then it has to be remanded to the agency. I mean, how could that be a workable rule?
So I think that
there's no case saying that, and I think probably for good reason, because it just seems wholly inconsistent with the way agencies operate. And it's also inconsistent with the way we review district court decisions.
So I don't think it would be an unworkable rule. And the reason why I don't think it would be unworkable is that many of the logistical sorts of matters that adjudicators would handle are committed to agency discretion by law. When the adjudicator set, the hearing is going to be on Monday and not Tuesday, that's not going to be something that requires an explanation. That's a matter of agency discretion. And for many others, any error is going to be harmless. The only
error here is harmless.
I'm happy to discuss harmless error. I don't think the error here is harmless. But the point here is that there's a relatively small set of cases where you're going to have an exclusion of important evidence and that the board is not going to give any reason whatsoever. If the board said excluded late, that may satisfy the reasons problem. We may still be here arguing that the reason is arbitrary and capricious, but it wouldn't be a reasons
Why
problem.
isn't the burden, though, on the party before the agency to ask for a reason? Because, on these sorts of preliminary matters, if they say, okay, we exclude this evidence and nobody challenges it, nobody asks for an explanation, perhaps it's just obvious to the parties why it was excluded because of untimeliness or irrelevance or whatever the parties assumed.
I don't think it should be the burden of the person in agency proceedings to have to force the agency to explain its rationale. And this case is particularly telling because while counsel did not stand up and say, what is your reason? He gave a lengthy explanation of why the evidence should be admitted. And the board did not say, we disagree with you, or it doesn't matter, it's untimely. The only response from the board was noted. And so counsel was left unclear as to why the evidence was excluded and whether there was something that could be fixed. But the board made clear that they didn't want to hear about it. I don't think it should be on counsel to have to affirmatively ask the board, you've made your ruling, now please explain it, even though I've told you why admittance is proper. On harmless error, I don't think the exclusion here is harmless, and I think it's most clear when looking at the penalty determination. The core of the board's penalty analysis was to determine that even though Dr. Schacht had her medical decisions had been validated. And even though the board determined that she could be successful at another hospital, it said, we can't have you come back to this hospital because you created a toxic environment at the hospital based on communications issues that went back far before fall 2017. The evidence that was excluded would have gone directly to the core of those findings. So Dr. Schacht sought to admit a report from the VA to Congress that investigated this hospital in particular and found that the problems at the hospital were caused by years of systemic mismanagement, not any one individual, as the board found. Dr. Schacht also sought to admit her performance reviews from prior years, showing that she met the qualifications on communication in every year prior to 2017, which rebuts the board's idea that these problems stretched long into the past. And Dr. Schacht also sought to admit evidence about a comparator doctor at the same hospital who was accused of similar communication misconduct and yet was given a substantially lower penalty. The board did not consider any of that evidence in finding that she was the core of the problem, and because she was the core and the ultimate cause of the problem, she had to be removed. Had that evidence been considered, the board well could have found a different outcome. So I think there is prejudice here, and this is not a particularly close case when it comes to prejudice.
I mean, your burden, the way that the burden has been articulated under 706 is similar to the Kodiakos standard of harmless error that applies like in non-constitutional harmless error that would apply in reviewing a civil or criminal trial. So it's your burden, and you have to establish some sort of a likelihood that there would have been a different outcome. Not just that this evidence was relevant, but that there would have been a different outcome, because there's no point in remanding if we believe that the outcome is going to be the same. So why is there a reasonable likelihood that any of this evidence would have led to a different outcome?
So it is our burden, although the court's case law has emphasized that the burden is not particularly onerous, and that the question is whether there might have been a different outcome, not whether it's guaranteed there was a different outcome. And the fact that the board could reach the same outcome on remand is not controlling. I believe there is.
I just wonder whether that's the argument that you're making is even the correct analysis. The error that you're posing was a failure to explain. The question is whether the failure to explain is harmless error. And if the record showed, for example, put aside your question, that it was clear as a bell that the proposal, the request was out of time, then that would be a harmless error that the court didn't explain itself. You would not take all the evidence that it excluded and then say, what if this came in? That assumes you have a valid argument. And the hypothetical I'm giving you is that you don't have a valid argument for its admission.
So that's not how the case was litigated below or how the case has been
Well, I
litigated
realize
here.
that. I realize that. I understand that. I'm just saying that I don't think it's so clear that it was litigated correctly.
I think the error is not harmless. And the problem with the Regents analysis is if you start looking and saying, well, what are reasons they might have given so it's harmless? That's at odds with the analysis that the court had in End Citizens United and in Regents itself. So in Regents itself, the Department of Homeland Security said, there is no point to a remand. There is no reason to think that the department secretary would do anything other than what is given in the Nielsen memo. And the matter would be remanded to the exact same decision maker if there's a remand. And the Supreme Court still said it doesn't matter. The reason it has to go back is because these are important procedural protections that serve values of administrative law. It doesn't matter if the government is right, that it will ultimately be pointless because the decision maker will reach the same outcome. But the hope is that when you have decision makers forced to give a reason for their actions rather than just taking actions, they will reach better, more reasoned decisions.
The only problem that you have is that it's not speculation. In this case, there's proof positive that the decision maker would reach the same outcome, and in fact did.
Well, respectfully, Judge, I'm not sure that's right, because on the terms of the district court's remand, the district court didn't remand to the agency to reconsider the issue. He just remanded for an explanation of what was already done. The agency was locked into a decision point. The remand did not give it leave to take any other action. Its only charge was to explain what it had done already, which is different from a remand, a general remand and a vacatur, which would send it back to the agency, and the agency could pick either path in the road and provide a reason that would support it. And the rationale.
Is there an argument below in the district court? I don't recall that the district court should not just simply remand, but should vacate.
I don't recall from the district court briefing, but I believe
What
the
if
argument
it wasn't?
If there wasn't a request for vacatur, I agree that could be a problem. But all I'm discussing is the point that it's positive, that we are sure and proof positive what the agency would do on remand, because that's not actually what happened. And the agency made the exact same argument, both in Regents and End Citizens United. They said, if you remand this, we are going to do the exact same thing on remand. And in both cases, the court said, that doesn't matter. These are important procedural values. And while procedures can often seem pointless, they serve real values of administrative practice.
Those are contexts in which there is a generally applicable regulation that applied, to private rights and duties. And you're saying that all of that is imported into a preliminary evidentiary determination in an adjudication.
So I'm saying that the duty to provide reasons is imported into preliminary steps of an adjudication. And we've not seen anything in the law that suggests that agencies are free to take unreasoned steps so long as they're preliminary.
Unreasoned, it's just that there's some, understanding about efficiency and process, for these types of preliminary matters.
I agree the rule is not efficient. And the Supreme Court goes out of its way in Regents to stress this is not an efficiency maximizing rule. It's ensuring that agencies do the process and do it correctly rather than skipping steps. So I agree it is not efficiency maximizing.
For rulemaking.
For rulemaking, although in his dissent, Justice Kavanaugh stresses that he doesn't think this rule should apply to rulemaking at all, and instead it should be confined to adjudications where the impacts on private rights are more obvious. He sort of draws a distinction between rulemaking and adjudications, but
there's no argument that the agency didn't give reasons about its ultimate decision. It's only about this preliminary matter.
I agree. They gave reasons about their ultimate decision. The problem is that their reasons about the ultimate decision are based on half of the applicable facts. To say they gave reasons for the ultimate decision when they didn't consider much of the material.
But maybe where there's a failure to object or ask for reasons below, then you've not exhausted that issue before the agency.
I mean, if the court wants to have this remanded so that we can take it back to the agency, that would solve an exhaustion issue too.
Well, no, I mean, if you haven't exhausted, we don't remand for then there to be exhaustion.
We were never given an opportunity to raise it at the agency because I think I'm going in a circle a little bit. The point is, appellant went through the whole agency process. It is true. There was no reason given. And the question is where to put the burden of the reason. We say the burden should go on the agency, who is the one exercising government power and impacting private rights, not on the person appearing before the agency. And ultimately, even if we lose that, I think we have a pretty strong fair notice problem because there's just nothing in this scheduling order that gives anyone an idea that it applies to exhibits. The agency itself didn't show that it understood the order that way. The board didn't show contemporaneously that it understood the order that way. And there's a number of statements elsewhere in the agency manual that talk about an ability to introduce evidence at the hearing. So the question on fair notice is just whether a reasonable person, when faced with this order, would have read it and said, other requests clearly applies to any request that requires the board approval, not just a request that is similar to a motion. And there's good reason to think that's not the case because it set separate deadlines for other items that did require board approval, like witness lists and objections to witness lists. There was never any deadline set for exhibits, and there was no deadline set to object to exhibits.
All right, any further questions?
No.
All right.
Thank you.
Mr. Brewer?
May it please the court. The board did give the reasons on remand, which is the remedy sought by Dr. Schacht in this case. And those reasons were that the evidence was untimely, plainly in the district court's word, and that it was irrelevant. And having now given those reasons, that it comports with the plain language of the scheduling order, and it comports as well with the notes of the pre-hearing conference, at which other actions were taken on requests for the admission of evidence. And as the questions noted, it comports with Dr. Schacht's own characterization of her pre-hearing request for the introduction of this.
Did the appellant argue below that the remand should be for reconsideration of the evidentiary ruling?
I don't know that below the appellant distinguished between that, but the district court allowed the agency the choice to either offer additional explanation or to reconsider its evidentiary ruling in light of the district court's first summary judgment opinion. And that appears at JA 20. And that's perfectly consistent with Regents, which said that the agency should be allowed to make that choice between those two options.
JA what?
20, Your Honor.
Government's view that a remand was necessary here for the agency to provide further explanation in this type of context?
We haven't taken a position on whether or not it was necessary, but because it happened and because the agency did provide those reasons on the remand, we think that those were sufficient to justify the district court's second summary judgment opinion. And as the district court explained, is consistent with Regents and it's consistent with this court's case law for the agency to be able to provide reasons on remand when directed to by a court. I'm happy to answer any other questions the panel has.
No, that's all you have. That's fine.
Thank you very much.
All right. Mr. Arnold, you used up all of your time. We'll give you 2 minutes for review.
Thank you, Judge. So I want to acknowledge that the government is correct that the district court's ruling both allowed the agency to provide an explanation or said the agency could reconsider the decision. So I apologize for misspeaking.
So why isn't that the end of your case?
I don't think it's the end of the case because the agency didn't reconsider. All the agency did was provide a post hoc explanation, and the court's case law and the Supreme Court's decision in Regents makes clear that the post hoc explanation will not do, and an agency decision cannot be upheld on that basis. So had the agency taken the district court up and reconsidered, even if it came to the same conclusion on reconsideration, that wouldn't be a Regents problem, but that's not the path that the agency took. The agency very clearly took a path of providing a post hoc explanation. And so the district court was wrong to uphold the agency action based on that explanation given years after the fact.
So in every adjudication before any administrative body, an ALJ, a board like this, if there's any ruling that happens in the course of that the losing party believes wasn't properly explained, they can challenge that, and then the remedy would be a remand for reconsideration, mandatory reconsideration of every single one of those unexplained rulings.
Where the district court concludes that the agency did in fact fail to explain itself in the original administrative record, which is the same thing that happened in Regents and the same thing that happened in End Citizens United. And the government just briefly mentioned the discussion of exhibits in the pre-hearing call. And there's a number, I think about 8 of those listed on JA 223. If the court looks at those submissions that are on pages 479 to 597 of the administrative record, none of them are styled as this is a request for introduction of hearing exhibits. Their motions and their witness lists where they have attachments in support of the motion or an attachment in support of the testimony that the witness is expected to proffer. There just isn't a time when either party put in a set of trial exhibits and said, here is our exhibits that we understood are due on October 7th.
All right,
It doesn't
we have
exist.
your argument.
All right, thank you.
Take the case under advisement.
This honorable court is adjourned until Wednesday, February 15th at 1:00 p.m.